First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Welcome to the First District Court of Appeal, virtual style.
Thank you.
And we have only one case on the docket. The second case having been continued after an emergency motion. So with that, I will call the case of Hall versus Carrie Brazier Center for Autism. Appellant may proceed.
Thank you, Your Honor. May it please the court, my name is Bill McCabe. I represent the claimant Uriah Hall, and I'll reserve 3 minutes for rebuttal.
Okay.
In this case, we submit the JCC erred when he denied claimant's request for authorization of a physician to evaluate and treat her injuries because the claimant is not at maximum medical improvement. The employer in this case stipulated that the claimant sustained a compensable accident and compensable injuries to her low back and her left leg. And the JCC in his order also found that the employer accepted compensability of the accident and the back and left leg injuries. Now, the judge also found, he says, the undersigned cannot determine, based on the evidence presented, whether claimant attained MMI. Now, this court has stated in 4 separate occasions or decisions that a claimant who has not reached MMI is entitled to have remedial care prescribed or provided by the employer. In fact, one of the cases, actually it was the first case where the court made that statement, the Lewis case. All these are cited in my brief. The court actually stated claimant is entitled as a matter of right in the absence of a specific finding that he has reached maximum medical improvement to have medical care provided by the employer. And when you think about it, it actually makes perfect sense because maximum medical improvement is defined as the date after which further recovery from or lasting improvement to an injury or disease can no longer reasonably be anticipated based upon reasonable medical probability. So if a claimant is not at MMI, then by definition, further recovery from or lasting improvement to an injury can be reasonably anticipated. In fact, the finding of MMI is actually precluded where there is a reasonable expectation the necessary treatment will bring about some degree of recovery, even if the treatment ultimately proves ineffective. So it's our position on this.
Let me ask you a question. So if we accept your argument, or if I understand your argument correctly, if an employer carrier accepts compensability of the accident, then in your opinion, they're on the hook for all treatment up until the time of MMI assignment, and there's no causation or requirement or burden for the claimant to show causation.
Well, there's no, I mean, actually, basically what you're saying is pretty much what my argument is. I mean, because there's no burden for the claimant to show causation because the causation's been stipulated to. The employer carrier stipulated that the accident was compensable and that these injuries are compensable.
The breadth of that stipulation, I think, is important here because when you're stipulating to compensability of the accident, that doesn't necessarily also relate to or define or stipulating to acceptance of compensability of every condition. You may have a compensable accident, but you may not have compensable injuries. So how are you stretching the stipulation that an accident's compensable to cover every causation issue up through MMI assignment?
Because they not only stipulated that the accident was compensable, but they stipulated that the injuries were compensable. They stipulated that the injuries to the low back and left leg were compensable. That's what they stipulated to. So I'm not stretching anything. I'm just talking about their stipulation. And
Counsel,
they haven't come up with any kind of...
Counsel,
Go
isn't
ahead.
it problematic under 440.13.2a that there was no finding of any need for remedial treatment or care for those conditions that you say are stipulated to?
Well, I believe that the necessity for the treatment is established by the fact that the claimant has not yet reached maximum medical improvement. I mean, think about it. If there's a compensable injury, but the claimant hasn't reached maximum medical improvement for that compensable injury yet, then of course it's necessary that they undergo further medical treatment. In fact, actually, this lady has not had any authorized medical treatment. I acknowledge the employer did offer her some treatment on 4 different occasions, which I don't know why the claimant didn't accept, but she didn't. But if you have compensable injuries, which the employer here has stipulated to, and the claimant's not an MMI yet, then obviously further treatment is necessary. Something's necessary.
But if no treatment was necessary in the first place, what does it matter, that there be a finding of no need for further treatment?
Well, we really don't know that no treatment was necessary in the first place. First of all, in the first place was months ago, but the 2 physicians that testified, the one whose opinion the JCC accepted, Dr. Evans, he stated that a strain sprain, which is what he diagnosed the condition as, normally heals within 6 to 8 weeks. But he never indicated that the claimant was at MMI. He never made any opinions about that. So he just said normally it is. So, I mean, who knows? The other doctor, Dr. Suarez, he did say that the first thing he wanted to do was an MRI of the cervical spine. And as the judge properly noted, the claimant didn't contend that the cervical spine was injured in the accident. But claimant's IME never said that treatment for the low back or left leg wasn't necessary. What he did say was, I really think we need to do the MRI of the cervical spine before I make any other recommendations. So,
but isn't it the claimant's burden to demonstrate, Mr. McCabe, isn't it the plaintiff's burden to demonstrate medical necessity for treatment following her PFB in April? So let's assume that perhaps she needed medical treatment after the accident for up to 8 weeks, which is what the JCC accepted from the medical expert. But beyond April, is there any competent substantial evidence in the record that the claimant needed any medical treatment that the JCC found to be credible?
There's no testimony in the record from any physician that says, I think it's necessary that this claimant have this, that, or the other for the low back or left leg. I agree with that. But as I said before, there's no testimony that the claimant doesn't either. But the claimant's not at maximum medical improvement. So my argument is that if a claimant has a compensable injury, which it's stipulated to here, claimant hasn't reached MMI, the claimant's entitled, really as a matter of law, to remedial treatment until the claimant reaches MMI for the accepted compensable injuries. And that's what this court has said on 4 different occasions. So I don't know how, I honestly don't know how the court can distinguish from the 4 cases that I've cited.
Couldn't you distinguish them based on the date of the amendments to the statute that require medical necessity, and that there be actual non-objective findings of medical necessity for treatment?
Well, I think the objective findings, doesn't that relate to causation? There's got to be objective findings, but I don't think the date of accident would have any difference. I mean, the theory is the same. If a claimant is not at maximum medical improvement for a compensable injury, they need authorized medical treatment. It's necessary until they reach the state of MMI. Now, it may turn out in this case that the claimant sees a doctor one time. The doctor says, I don't think there's any further need for treatment, and that's the end of it. That might happen. I acknowledge that there are cases, the Echeverria case, that holds once a claimant reaches MMI, even if the claimant has a permanent impairment, the claimant has to present testimony of the medical necessity of further treatment. But prior to a claimant reaching MMI for compensable injuries, it is I submit that the claimant doesn't need any further testimony than that. Causation's been established by stipulation, which the JCC found happened. Necessity is established by the fact that the claimant's not at MMI yet for those conditions. And I might add, the employer carrier hasn't come in and shown any new cause, perhaps, for those injuries. So, I don't know why the JCC said he couldn't make a determination on MMI, but he said he couldn't. And he was given a chance when the claimant filed the claimant's motion for rehearing, pointing out these cases that I've cited in my brief. And the judge didn't really address the MMI issue. He just went back to saying, I don't find any testimony saying she needs the treatment. So my argument is a pure question of law, and I base it on the 4 cases that I've cited. So I guess I'll reserve the rest of my time for, unless there's other questions right now.
Thank you. Counsel for appellee may proceed.
Good afternoon, Your Honors. May it please the court. My name is Gladys Koya, and I represent the appellee, Carrie Grazer, Center for Autism. It seems that the appellant's sole argument here is that because she hasn't reached maximum medical improvement, that she is entitled as a matter of law to medical care. On the contrary, it's the claimant's burden to prove medical necessity for the treatment that's being sought. And this is reflected throughout Section 440.13, which is medical care. Specifically, 440.13.2a, the employer shall furnish to the employee such medically necessary remedial care. For example, there's the 440.13.2c, which is known as the self-help, which indicates that if the employer fails to provide initial treatment, that the employee may obtain such initial treatment at the expense of the carrier or the employer if the initial treatment or care is compensable and medically necessary. Again, with the 440.13.2f, which is the statute regarding one-time change of physicians, it states that if the carrier doesn't respond to the claimant's request for a change of physician within 5 days, that physician would be considered authorized if the treatment being provided is compensable and medically necessary. The only time that I have seen, the only statutory scheme that I have seen where the carrier would have to consent to medical treatment is if when the carrier fails to respond to the referral from an authorized healthcare provider to treatment. And a carrier who fails to respond consents to the medical necessity for such treatment. There is no other provision in the statute, and the case law is quite clear that a claimant still has to establish medical necessity. Now, to the issue of compensability and medical necessity, compensability is governed by 440.09, and that deals with the causation, the accident. Did the accident arise out of the course and scope of the employment? That's separate and apart from medical necessity. Entitlement to medical care is governed by 440.13.2a, which clearly requires a showing of medical necessity. The Morrow versus Sam's Club case, this court held that the denial of an ortho based on 440.09 was incorrect. It was supposed to be evaluated under 440.13.2a. The Echeverria case, which Mr. McCabe alluded to, indicates this court. It's interesting that this court indicated we write only to respond to claimant's argument that as a matter of law, his permanent impairment rating assigned for his compensable injuries entitle him to ongoing palliative treatment, even in the absence of any medical testimony establishing a need for treatment. Neither the relevant statutory provisions within Chapter 440 nor our case law establish such an entitlement in the absence of evidence of medical necessity for the treatment defined in part as appropriate to the patient's diagnosis, the diagnosis being the compensable injury. Again, in the Perez case, which is once the claimant establishes that the accident, the injuries are compensable, even in the Perez case, this court stated that the claimant still retained the burden to establish other aspects of proof required by statute, such as the medical necessity of the requested benefit, citing to 440.13 2A. So, Your Honors, there is absolutely no evidence, medical evidence, in this case that establishes that the care that the appellant is seeking for her back and her left leg is medically necessary. Her own IME physician opined medical necessity for her neck, which is not the compensable accident or injury. I'm sorry. The employer's IME, to the contrary, opined that there was no medical necessity for treatment for the back and the leg, and the JCC accepted the doctor's opinion, and therefore there is competent substantial evidence to support the judge's ruling. I do want to point out that all of the cases that have been cited by the appellant and the appellee as well, I'll admit, all of those cases, the injured worker had already had medical care. And it was just a matter of all the subsequent recommendations for medical care. This lady never had initial medical care. It was her right under the self-help provision of 440.13 2C that if the employer failed to offer her initial treatment, she was free to go and seek initial treatment on her own. And then if she proves that the initial treatment was compensable and medically necessary, then the employer would have to bear the expense of that treatment. So the running theme through all of this, Your Honors, is that there must be medical necessity established to obtain medical treatment, irrespective of MMI. This court, I'm sure, did not mean to provide or make the claimant prove medical necessity only after MMI and not before. It just seems illogical that the legislature, illogical that the legislature would intend that, and illogical that this court would support something like that with maximum medical improvement. So based on the foregoing, Your Honors, I respectfully request that the JCC's ruling be affirmed. Thank you very much.
Thank you. Rebuttal?
Can you hear me now?
Yes.
As it said, I got muted when she was arguing, and so I had to unmute. But anyway, again, it's my position that the necessity is established by the fact that the claimant is not at MMI. So if further medical
I
treatment...
have a question. Whose burden is it to establish MMI?
Well, if the employer carrier wants to use it as a defense, I think it's their burden. And the parties had differing opinions in this too. The employer thought the claimant was at MMI or took that position, and the claimant said the claimant was not at MMI. So, but the judge said he couldn't make a determination. If the claimant...
Would the appropriate remedy be a remand and direct the judge of compensation claims to make that finding?
Judge, I thought about that, but
Great minds think
problem
alike.
with that. Thank you. But the problem with that is the judge in this case specifically said on the evidence presented, I'm unable to make a determination. So
But
if you
don't we have
remand
to
it,
have a determination of MMI in a workers' compensation case like this?
I admit that MMI is an important, yes, it's an important thing to find, but I'm thinking
Because your
that if you could-
argument is essentially that MMI is synonymous with necessity. I mean, that's your logical argument, right?
MMI, the treatment that the client gets is remedial treatment, is what it's called. After MMI, it's called palliative. Yes, my argument is a matter of law based on those.
Mr. McCabe, we're having technical difficulties.
Okay, I'm sorry. Can you hear me? Do you want me to call in?
I'm not sure if some folks on our end can help you. There's
Mr.
a lot
McCabe,
of
can you
reverberation.
call in?
Judge?
Yes.
Okay. I'm forgetting a little bit where I was, but I think what my argument was that, yes, necessity is established by not reaching MMI for remedial treatment. Palliative care based on Echeverria, you got to reestablish necessity again. But before that, no, on those 4 cases that I've cited.
Well, I don't think I've ever seen a case where a judge of compensation claims said, I can't make a determination on MMI, but I don't find any necessity for additional medical treatment. That almost seems like 2 contradictory worker compensation legal principles.
It may be. I mean, I find no case from this court that contradicts or gets around or anything else.
But the cases you cite, there was either a dispute or we held, or the judge of compensation claims found additional treatment could be necessary, correct?
I don't really want to say one way or the other, but I don't
Well,
think
I mean,
so.
we've never held squarely that if a judge of compensation claims can't make a determination of MMI, then even with a finding of no medical necessity, a claimant gets to continue to receive some kind of benefits under the statute, right?
I don't think there was a case like that. Actually, the first case that I cited, the Lewis case, the court did remand it to the JCC to make a determination if there was MMI, and then to determine whether claimant's complaints of pain were credible, and then if so, whether the claimant should see another doctor. So that case, you did remand it, but no.
Correct me if I'm wrong. If we agree with you, we have to say, even though the evidence shows no necessity of treatment, in fact, she basically refused treatment, it seems like. Even though there's no necessity for treatment, because the judge can't make an MMI determination, she has to receive treatment. That's your argument.
Well, I'm not sure that there's no necessity for treatment. I admit that no doctor said she needs this treatment or that treatment for the low back or leg, but I'm not so sure a doctor said she didn't. The employer carrier's IME did say that the strained sprain, which is what the judge found the lady had, should heal in 6 to 8 weeks. He said should heal, and did say that the claimant was at MMI. But I just think if you're not at MMI, then it is necessary to have more treatment till you get to MMI.
And your argument is it's the employer or carrier's burden to prove the negative to prove the affirmative that the claimant is at MMI in cases where the injury is stipulated and some treatment is conceded?
I would think so if that's what they want to use as a defense to the claimant receiving any further treatment.
And this court has never held whose burden that is?
Judge, to be honest, I really don't. I should know something like that, but I just don't. I really don't.
No, I'm not implying you should know it. I'm sort of flabbergasted. We've not said who has the burden. But to be fair to the appellee who left 8 minutes on the table, you, and we have no objection to that, by the way. I can assure you of that. That, Mr. McCabe, you're already over your time, but I'll let you have a little bit of appellee's time for a brief conclusion. Without objection from the appellee.
No objection, Your Honor.
Okay, well, Judge, I certainly appreciate you letting me go over time. I apologize for if anything was at my end, but I really don't think I have anything to. I don't think I have anything to add. I just appreciate giving us the opportunity to do oral argument, and it is pretty nice actually by Zoom. I mean, it does save a lot of travel time, et cetera. So, but thank you.
Thank you. Thank you both for your arguments. The court will be in recess.
Thank
Have
you.
a good weekend.
You too. Thank you.